Hi, everyone. Thank you so much for attending this panel. We have a fantastic guest today to speak about an extremely hot topic in antitrust enforcement. My name is Ademir Pereira. I'm a partner at Advocacia del Chiaro, and I'm the co-chair of the competition committee at Ibrademp. Moderating this panel with me today, I have Suzana Fagundes, my co-chair at the committee and a general counsel at Localiza. Our panel today is titled When Antitrust Meets Human Resources, Experiences from Europe and the US, and Next Steps in Brazil. We thought about this panel because a few weeks ago, the Brazilian competition agency, CADE, launched a large investigation into human resources practices of several companies in the medical device industry. This is the first of its kind in Brazil. As a result, this topic became extremely relevant among Brazilian practitioners, and many legal departments are looking for advice. While this is a somewhat new topic in Brazil, it has been subject to lots of discussions in the US and Europe for the past few years. Our panel then has great experts from Europe, the US, and Brazil who will share their experiences in handling these matters and will discuss potential next steps for companies doing business in Brazil and abroad. This is not an intuitive topic for business people, and it's a highly uncertain area of law. All of that can make counseling clients especially challenging, so we should expect a lot of questions and gray areas. Hopefully, with this panel, we can bring a little bit of clarity on certain topics and, most importantly, flag issues that will demand further discussion and careful and strategic thinking for companies and lawyers. Let's kick things off then, and let me first introduce our panel. So we have today Dr. Christian Stein, a partner at Gleiss Lutz in Europe. Christian is one of the leaders in this field and has considerable experience in European and international antitrust law. He focuses on cartel cases as well as private antitrust litigation, merger control, online and distribution antitrust law, antitrust compliance program, and internal investigations. We also have here Gaglio, a partner at Axinn, a top antitrust boutique in the US. Nick's based in New York and draws on nearly 20 years of experience to counsel clients across a full range of antitrust issues, including civil no merger and criminal cartel investigation, internal investigations, litigation, mergers, and counseling. Finally, we also have here Luis Nagalli, a partner at Advocacia del Chiaro in São Paulo, who has represented domestic and foreign clients in notifications of mergers and acquisitions, as well as unilateral conducts and cartel investigations in various sectors, including auto parts, technology, equity funds, and consumer products. Okay, guys, thank you so much for being here. It's a great pleasure to have you all. Let's go with the questions. I mean, we do have a lot of ground to cover today, so we should start right away. I'd like to start with Nick, as the US has been in the forefront of certain of these issues and has been probably one of the first countries to enforce the law against wage fixing and no poaching. And again, I mean, I understand that these are key concerns in this debate involving human resources. Nick, can you tell us what wage fixing and no poaching are and how enforcement in the US has developed?
Sure, and thanks very much, Ademir, and thanks to Suzana and to Ibrademp for the opportunity to speak on this great panel today. And of course, I'll kick off with an ask for the audience's forgiveness if we run into any work from home perils, like my dog barks, we lose the internet for a moment, or my head turns into a cat. So just to start with some quick definitions, wage fixing is any agreement among competitors regarding the salary or other terms of compensation. So for example, this can be specific as to salary. You and I were paying $100 before, now we agree we will pay $75 going forward. It could also be a general agreement not to offer raises. If Luis and I are the only employers of nurses in a given market, Luis and I might agree that if a nurse at Luis's shop says, hey, Luis, give me a raise or I'll go work for Nick, he will refuse to give her that raise because he's safe in the knowledge that I have agreed not to hire her. It could also be an agreement on benefits levels or other in-kind compensation. So any agreement on salary or related terms. Now, a no poach is an agreement among competitors not to solicit or hire each other's employees. And this, again, can encompass a broad spectrum of conduct. So it could be a simple agreement that they won't cold call each other's employees, but if an employee approaches them voluntarily, they can hire them. Or it could be a straight no hire agreement. It could be, I won't hire you unless you can, I won't hire one of your employees unless you consent, or I won't hire unless I give you notice. It could even potentially be having an internal do not call list, depending on how that call list is generated. So lots of spectrum for gray area here. Now, a couple of important points to keep in mind. When I say competitors, in this context, we are not talking about just competitors downstream in the way that we traditionally think about it in competition law. We are talking about competitors for reasonably interchangeable labor units. So those two things might intersect. For example, in a specialized industry such as the railway industry, it might be that they are both competitors downstream and competitors for a limited set of specialized employees. However, enforcers can, and in the US have viewed quite different companies as competitors for employees. Take just hypothetically Coke and Amazon. We might not think of them as direct competitors downstream, but if they have a distribution center in the same city, they might very well be competitors for those distribution center employees. Obviously, this can add complexity as well when you have relationships such as customer, supplier, or joint venture partners who are in a mutually cooperative transaction, but may at the same time, in the views of the enforcers, be competing for talent. Now, before I jump into the enforcement issues, I do need to just quickly flag three kind of preliminary concepts in US law. The first concept is that we have two analytical frameworks for antitrust violations, the per se rule and the rule of reason. Per se violations require no showing of competitive effect or injury, simply a showing that an agreement to engage at the conduct at issue was reached. Typically, in the US, per se treatment has been reserved for restraints with which the courts or enforcers have a lot of experience. Now, on the other hand, the rule of reason requires an analysis and a balancing of the pro-competitive and anti-competitive effects. So for example, you might look at market definition or market power. You might look at entry barriers. You might look at actual price effects, causation, injury, legitimate business justifications, efficiencies. All of those things need to be taken into account. But the key takeaway for this audience is that the DOJ for decades has been asserting that naked no poach and wage fixing agreements are per se illegal. And as a result, you need to be particularly vigilant if you're operating in the US. Now, there is nuance here, which we'll get into because the US government has submitted some filings over the past few years indicating that in certain contexts, the rule of reason might be applicable, such as in the franchise context, but the courts in the United States have not yet decided that. That is to be determined. So that's point one, per se, most likely treatment of no poach and wage fixing. The second point is that we also have two different options for enforcers to pursue cases in the United States. They can pursue them civilly, or they can pursue them criminally. If they pursue them criminally, that means that individuals can face potential imprisonment and significant fines, and there is a significant fine structure for corporations that are found guilty of criminal violations as well. So the key here, again, is that the risk is elevated. If you're operating in the US, you need to be aware that these wage fixing and no poach agreements are being pursued potentially criminally. And the other thing I would add here is that that means that you may have the opportunity, if you discover misconduct in this way, to take advantage of the DOJ's leniency program. And we'll probably get into that shortly. The final concept in the US that you need to understand is that we have a multi-tiered enforcement system. That means that it's not just federal enforcers, but state and local enforcers. And also we have obviously a robust private damages system. So the risk here does not arise purely from clearly criminal no poach and wage fixing because you have significant treble damages liability as well. Having put those concepts aside, I'll now move quickly through the development. It goes back about 30 years when some economists started writing about monopsony power and the agencies brought their first investigations and consent decrees in the space. But really, it comes to most people's attention around 2010 when the DOJ entered into consent decrees with a number of high-profile Silicon Valley companies that had entered into a variety of no-poach arrangements, some not to recruit, some not to cold call, some not to hire outright, others not to engage in bidding wars for talent. So again, we see that no poach can encompass a broad spectrum of conduct. All of those cases were resolved by consent decree. The real watershed moment in the United States, however, comes in October of 2016 when the DOJ issues their guidance for human resources professionals. Here, the DOJ lays out its intent to pursue naked no poach and wage fixing actions criminally. And they also discuss information exchange risks, ways to mitigate that risk, and they provide a number of helpful hypotheticals and examples intended to help HR professionals train their teams and steer their companies clear of misconduct in this area. And if anyone has questions in this on this issue with respect to the US, I recommend that you start with the HR professional guidance because it is very helpful. Now, even with that statement of intent in 2016, 2 years later, the DOJ is still bringing civil actions, most notably against two of the world's largest railway operators, Knorr-Bremse and Westinghouse Airbrake Technologies Corporation, which I'll just call Wabtec for purposes of this discussion. Now, in that complaint, it wasn't a wage fixing, but rather a simple no poach. It was an agreement among the company's executives not to solicit or recruit, hire without prior approval, or otherwise compete for a small subset of skilled railway employees. Now, after that, we see a flurry of activity in the United States, both on part of state attorneys general, particularly in the franchise quick serve restaurant space. There's also a significant amount of academic work, including some notable papers out of Princeton by Kruger and Ashenfelter, some work by Ioana Marinescu, and also Eric Posner at University of Chicago. And this really gets the discussion going within the competition community. The DOJ, in the meantime, continues to express its goal and its desire of bringing cases criminally. And although we don't see cases until December of 2020, they do submit a number of statements of intent in existing litigations to help try to clarify the boundaries of which no-poach arrangements should be treated per se and which no-poach arrangements might be better analyzed under the rule of reason. Finally, just a few months ago in December of 2020, we see our first criminal indictment in the United States, now of a former owner of a physical therapy staffing agency. This is a very straightforward wage fixing case where, according to the indictment, he was calling up 5 or 6 of his competitors, texting information back and forth with them about the reimbursement rates that he was paying his physical therapists and inviting them to agree to reduce the salary paid to physical therapists. After that, in March, DOJ indicted a company and former manager on an agreement for non-solicitation of wage caps in school nurses in Nevada, in Clark County, one of the biggest school districts in the United States. That there was not just an agreement to no poach, but also an agreement not to give raises, similar to the example that I gave earlier. And we also saw earlier a straight no poach in a medical facility operation where executives were agreeing not to solicit other executives within that industry. So in total, we have now 3 criminal indictments, including both individuals and corporations. Back to you, Ademir.
Thank you, Nick, very much for your clarification. It's very scary what you just said for us. I'm sure there are many lawyers here that are very concerned to see how developed the U.S. jurisprudence on this matter is already. This is a topic we've been talking with Ademir for some time already, but I'm sure it was not on the agenda of most companies or HR professionals at all in Brazil. So thank you very much. And so I turn to Christian to ask you, how is the European experience? I hope it's better than the US, that is not so strict. And if there you also have the same practice of considering the wage fixing and no poaching agreement as a per se rule or not? And if so, if there is an exception, because as we saw in the US, there are very few. To you, Christian.
Thank you very much, Suzana, and thank you very much for inviting me to this great event. Yeah, let me give you a quick overview of the situation in Europe. It's less frightening, but I should say still less frightening. It is up and coming because HR, as in most other countries, has become one of the key cost elements. We have the war for talents. Companies are struggling to get very good software engineers, very good other professionals. And so cases are increasing, and awareness among antitrust authorities in Europe is also increasing, but we do not yet have any quasi-criminal case law. So you will not find one single case of the European Commission where it imposed a fine because of no poaching or wage fixing. However, if you look into the law in Article 101 of the treaty, then it's very clear, unfortunately, very clear that of course, any fixing of prices also on purchasing markets, including wages, can constitute a restriction of competition by object, and is very likely going to constitute such a restriction by competition by object. There is just one important exception, and this has been confirmed by the Court of Justice already in 1999, that collective labor agreements, they do not fall under the cartel prohibition. So they remain lawful, and this has huge practical consequences because similarly to Brazil, trade unions play a very important role in Europe. And also representatives of the workers, they also like to gather and like to exchange information. And this is still permissible insofar as it serves the purpose of facilitating, preparing, or implementing collective labor agreements. And so the same is true on the employer side. Employers need to gather, employers need to discuss information that is relevant for their collective bargaining. And insofar as such collective mechanisms are concerned, there can be binding agreements, so to speak, wage fixing agreements, but they are clearly illegal outside the scope of collective agreements. And in particular, the more highly paid employees, let's say, for example, software engineers, they rarely fall under a collective labor agreement. And so if a car maker and a software company would agree on wages for software engineers, that would be a restriction of competition by object under EU competition law. And what Nick already mentioned is, of course, the same here in Europe. Be very careful with whom you consider as a competitor on such a market. Yeah? Just to use this example of the software engineer for a last time, in these days, so many companies from so different industries are hiring software engineers, not just the usual suspects, yeah, but Volkswagen, for example, has decided to hire thousands of them. Yeah, so they are of course competing now with companies like Apple, like Google, etc. And the same is of course true for more neutral jobs like controllers, etc. So no matter whether companies compete downstream, they can still perfectly be seen as competitors on the labor market. And if you look into cases, as I said, there are not yet standalone wage fixing cases. But what you can see is, for example, in a German case from 2016, where 2 TV studios were found guilty of having exchanged information, The information exchanged did not only include pricing information for their services, for their TV services, but also purchasing related information, including the compensation paid to freelancers and to other staff. And this was part of the fine decisions. Not sure whether the authority, the Bundeskartellamt, would have imposed the fines if that was all they found, but since it was part of the collusion, they did not hesitate and included it into the guilty plea. Back to you.
Interesting. Thank you so much, Christian. I'll just get back to Nick very quickly, just to give you a chance to develop a little bit on potential exceptions. That's a helpful question that Suzana raised. Can you elaborate, Nick, a little bit?
Yeah, so it's a little bit similar to what Christian was talking about, in that the US does have a first principle, essentially, that where non-solicitation or no poach, if you will be allowed is in substantively and temporally tailored situations. So where the restriction is closely related to some sort of legitimate joint activity, and where it is limited only to the employees necessary to protect that legitimate interest, and only for so long as it is necessary to protect that legitimate interest. So to give a couple of examples here, in the merger context, it would still be appropriate to have a non-compete and non-solicitation, so that if as a seller you invite a buyer in to interview your management, they will not turn around after terminating their interest in your deal and hire away all your best talent. So that kind of limited restriction would be fine, but of course that non-compete or that non-solicitation would not be able to go on forever. Similarly, in the context of a joint venture, if you had employees from two joint venture partners working together, perhaps having access not only to each other, but to proprietary information, maybe they're sharing facilities. In that situation, a limited non-solicitation, we believe, would likely pass muster. I think we're going to talk a little bit later about benchmarking agreements. That's a situation in which information exchange can be done in a way that mitigates risk. And of course, we have vertical type arrangements. I mentioned franchises earlier, but supplier-customer relationships using a similar logic to joint ventures might also create situations in which a narrowly tailored no poach could very well be legal. Think of, for example, in a consulting context where a consultant comes in, has access again to your proprietary information and your employees, that consultant would have to agree not to solicit your employees for an appropriate amount of time. But again, the key here is to articulate a legitimate business justification for the non-solicit and to ensure that it is limited both substantively and temporarily. And we can get into that a little bit more later in the conversation.
Thank you, Nick. Of course, it depends on who decides what is legitimate or not, right? So many business people think everything is legitimate and necessary to the business, and we have to convince that for antitrust reasons, that's not. So, but
Suzana, just quickly to pick up on your point, and Ademir said this at the outset, in our experience, this is a big issue because unlike other aspects of competition law, this restriction on employment, either information exchange or what people might consider business courtesies between transaction partners, it's not intuitive to business people. So we have a real obstacle simply to make people aware of why this is illegal, not just that it's illegal, but why it's illegal. So I sympathize with the point that you're making.
Yeah, and not only to business people, but even to corporate lawyers. That's not intuitive. So that's sometimes we have a hard time. So going back to Brazil, Luis, what is the situation in Brazil? It seems that there's no specific law setting that what you can do and what you cannot do, as it is also in the US and in Europe in some cases. So do we have any guideline issued by CADE, and should we be concerned also here about wage fixing and no poaching, or should we wait for the results of this current investigation that is going on?
Thanks so much, Suzana and Ademir, for inviting me to once again speak at the IBRDEM's Competition Commission. It's a pleasure to be here. And it's also an honor to divide this panel with my friends, Nick and Christian. I'm sure I'm going to learn much more that I'll be able to collaborate. But at the end of the day, I think I have the easiest job. We're talking about just one case that is a very initial stage, right? But as Ademir mentioned at the beginning of our panel, we have the first ever case in Brazil targeting this human resources practice. And what we have now to work with is just one first accusatory piece, which is a technical note that was issued to support the launching of the investigation. But there are already important key takeaways that we can have from this technical note that I'll be happy to share with you. But getting back to specifically your question, Suzana. So first of all, we don't have a specific guidelines in Brazil. But as I mentioned, I mean, in this first accusatory piece, the general that it was issued by the general superintendents, right, which is the investigative body at CADE, which will, this case will also be reviewed by the tribunal, which will have the final word on the case. But this first piece is already flagging that Brazil is basically following the same path as we have in the US and the EC, right, and Europe. So wage fixing and no poach agreements are seen to be per se illegal. So I'm going to talk about per se, but as Christian correctly used it, what we talk here is actually infringement by object, right? And there are minor differences. I'm not going to, I think we can leave this to another day. I'm going to use both per se or illicit by object just to make it easier for the purpose of this conversation. So that's basically what the general superintendent is saying. I mean, these wage fixing agreements and no poach agreements are a type of collusion, and they're actually could be per se illegal, right? Specifically about exceptions, the general superintendents also mentioned the collective bargaining. I mean, it's similar to what we have in Europe, the collective, especially in Germany, the collective bargaining negotiating with unions. So there is a specific paragraph talking about that this is not going to fall under this type of infringement. And also, as Nick brought on the non-soliciting clauses, right? You have this non-solicit clause included in JVs and acquisitions, and that's something that CADE actually has been dealt with in the past years. This is not something new. I mean, CADE has been accepting those type of clauses to the extent that they are necessary to the implementation of the deal, right? And in those cases where the employees are a relevant part of the business, or they're a relevant part of the business value, right? So that makes sense. I think we're following the same, we're talking about the same thing here, both in the US or in the EC. But talking about the exemptions and how difficult it is to deal with that, I just want to give a scenario so we can discuss this. So imagine a world where we have a very specific market with 15 companies, right? And imagine that those 15 companies, they are organized themselves through an association in a way that they will have been placed in a particular order where they will be able to pick the best graduate students, or I mean, the employees are just entering the market, and they'll be able, one by one, to make an offer to this specific former student and just new employee in the market. They're the best in place. The other companies, they are not going to make an offer to this employee. And basically this employee, if they want to work in this specific segment, they will have to accept the offer in the terms that the offer was made, right? That's basically what we're talking about. So basically what we're talking about is a type of no poaching agreement, right? And this, and I'm exaggerating to make an example, but this is actually happening tonight. So tonight, and we'll be broadcasted around the world because tonight we have the NFL draft. And it is, for the non-American football fans, the draft is basically what I'm saying. You have those teams placed in order, right? And they are able to make a pick or make a draft for the best players that are just made available to the league. And this was actually challenged in the 70s by one former Washington football team, James Yazoo Smith, and he was basically saying, well, I mean, this violates the Sherman Act because I just have to accept the offer that was made to me. And in this particular player, he had a career-ending injury in the first season, and he was basically suing the NFL and the Washington football team, basically saying that he was not able to make more money and he had to live with what he was able to make in this first season because of the way the draft is made. And in a parallel case that was filed almost jointly, the Supreme Court actually decided that all professional sports leagues drafts, the way they are doing, are actually legal, right? And that's because basically, and I'm oversimplifying this, I don't want to step on Nick's court, but basically what they're saying, what the Supreme Court said is that there are efficiencies related to this draft. And what are those efficiencies? The draft actually allows the worst teams to get the best picks, right? So the teams are ordered in a way that the worst teams, based on their last results and the last championship, the worst teams, they can pick first, and therefore they could pick the best player. So this could bring balance to the competition in sports. So I'm just bringing this example to explain how I mean, that's what Nick was saying, what Ademir is saying, how difficult it is to deal with the situations, how nuanced are all these cases. I mean, if you change the context, maybe you change the effect of the conduct. So you need to be very careful when analyzing this. And I also want to make a point that even though, as Nick said, this was mostly discussed around 2010, it's something that was around in the US system since the 70s, and we're just having our first case now. So it's something that we definitely want to watch how it's going to develop in Brazil. So back to you.
I mean, that's all very interesting, and you guys are saying that it's nuanced for wage fixing and no poaching. I mean, what can we say about information exchange, right? I mean, is there more clarity there, or it's tougher than the discussions we were having right now? And that's I think one of the things that we're very curious about. I mean, we've been receiving lots of questions in our practice. I've been speaking to Suzana and other people, in-house counsel. They're all saying, I mean, we need clarity. We need to understand what type of benchmarking and information exchange can happen, right? I mean, what can we do here? So I'll start with Christian this time. I'll give you, Christian, the first shot here, which is tough. But what type of information exchange involving, human resources policies could be problematic? And what type of framework of review we should expect here?
Well, this is probably the most disappointing topic to be discussed, at least disappointing for the HR colleagues, because here we have a clear discrepancy between what is happening in reality in Europe and what is legal. Yeah? In reality, and I'm not naive, I'm fully aware that HR professionals, they love to exchange information. They love to benchmark their own recruitment activities with those of other companies. They love to learn what has proven to be successful, which benefits really pay off, which are really highly valued by employees and which can make a difference when hiring good professionals. But from a competition law standpoint, very often this type of exchange is highly problematic because we do not have a more generous rule with regard to exchanging HR-related information. If this information is competitively relevant, then it has to satisfy the same requirements like any other competitively sensitive information. And of course, everything that is relevant to competition on the HR market is and has to be seen as competitively relevant. And so you can only exchange it under EU competition law if the information is sufficiently anonymized, if it's sufficiently aggregated, if there is a neutral third party that is doing a professional benchmarking and make sure that there is no tracing back of individual company information to individual participants. And this is not really what we see in practice. So in practice, there are still too many direct exchanges of information without any neutral third party and without sufficiently aggregation and anonymizing the information. As I said earlier, until now, we're still waiting for the big bang in terms of enforcement. So you might still have a bit time to adapt to the rules, but there can be no doubt that HR professionals have to be very careful and should definitely stop exchanging directly with other companies competitively sensitive HR-related information. And in this example that I mentioned earlier about these TV studios, there was the clear statement that it didn't need to be shown whether the information exchanged actually led to a coordination of behavior or not. Because as you probably know, EU competition law is very strict on this. It is sufficient that information is competitively relevant, and it is not necessary to show that the outcome on the market is then parallel. So to make a long story very short, we need to convince our HR colleagues that we need to modify certain practices, that we need to involve neutral third parties, and that we, in some cases, even need to refrain altogether from exchanging certain information.
Thank you, Christian. I think that the big question here is what is really sensitive in terms of antitrust. Every information, for instance, for HR safety and standards or other issues that are not directly linked to salary itself. And also that's the problem is the gray area, right? So in addition to everything that you said, that some people have less sensibility for that. And especially, Nick, I'd like to understand the US experience on that as well. And this is the big question I think we have, know which are really the sensitive information that cannot be shared and which would be acceptable in the day by day. For instance, we are in the pandemic moment and we went from working in-house to at home suddenly. And so we, HR people are exchanging several practices, how to do there, because it's not just a moment, now it turned to be something permanent. So to what extent we can exchange? And more, if we exchange this kind of with information with non-competitors or on our main competitors, so would that be allowed, or would this restriction, I think Christian already mentioned a little bit of that, and you as well, but would we be able to exchange sensitive HR information with non-competitors? Would that be okay? I'd like to hear from you.
Yeah, and I think, Suzana, it begs a question, competitors for what? So if you could satisfy yourself in the United States that the information you were exchanging was with parties that you never competed for any employees, then you would be at a zero risk situation. But unfortunately, depending on the nature of the client and depending on the nature of the employee set, you may find it very challenging to do that. So, what I would advise your clients in that situation would be this, that at least in the US currently, while information exchange standing alone can violate the antitrust laws, in general, it is analyzed under the rule of reason, which means with the appropriate safeguards, and this gets to the second part of your question, it can be exchanged in a way that mitigates the competition law risk. So let me, that's a little bit of good news that it's under the rule of reason and that we can articulate a legitimate business reason for it and shape the way that the information is exchanged and the type of information is exchanged. The bad news is that, I think what that sometimes does is it causes clients to underestimate the risk associated with information exchanges. So this picks up on Christian's point and another point we made earlier, that HR professionals have been doing this for a long time. HR professionals love salary surveys, benefit surveys, employee demographic surveys, and ultimately all of these things carry potential risk, and it's really important, therefore, to structure them in the right way. So let's talk about how this is analyzed. Now, in the US, we have extensive experience in information exchange going back more than 20 years. There was a Second Circuit case relating to the exchange of compensation information in the petrochemical industry, where a circuit court of appeals actually sent the case to the jury on a rule of reason theory. So there's no question that these types of exchanges could violate the antitrust laws. More good news, however, we have significant guidance from the US government in the form of the Competitor Collaboration Guidelines, another document I recommend to anyone with questions about that. There's a specific section around information exchange. The Statement on Antitrust Enforcement in Healthcare also has a particular section, Statement 6, that provides effectively a safe harbor for certain kinds of information exchange. And of course, we have, this ability to look at the information, and this really gets to your question, Suzana. So a few elements here. Number one, what is the competitive sensitivity of the information, right? Downstream price is always, forward-looking price is always more sensitive than cost or other pieces of information. In the compensation framework, salary and direct compensation related terms, benefits are a good example. Those would be higher risk, whereas things like demographics, duration of employment trends, that kind of HR information, probably lower risk. The second element is the recency of the information. So prospective salary and compensation benefits information is almost always going to be problematic in the US, given the current enforcement focus. Current is higher risk than historical. So one of the challenges we have here is that as data ages, it gets less commercially useful to our business people, but it reduces the risk from an antitrust perspective. So there's always a push and pull. How much can we delay the release of this information before it loses its value in order to reduce that risk? The third element is the specificity of the information. So aggregated and anonymized information is always lower risk than identifiable information. So if I can see particularly which company this compensation information relates to, that's going to be much higher risk than an aggregated number, right? And then the mechanism of the transmission is a factor, as Christian already said, using a third party to collect the data so that you don't have competitor to competitor discussions, and then having that third party administer the dissemination of that data, particularly if they will aggregate it, anonymize it, and hopefully, if it can still be useful, delay it. That will all mitigate the risk. Okay, so really to answer your question, Suzana, is unfortunately it depends. But what I would advise is that clients take advice, they use third parties, and they aggregate it, anonymize it, and delay reporting out the information as much as they can, consistent with commercial viability, if that makes sense.
That's great. Thank you, Nick. So, Luis, when we turn to Brazil, we actually got a question from our audience, which I think will be helpful for this discussion. When we got this question, thank you so much. It's saying, it's pretty common for companies in Brazil to check which are the benefits. For example, other companies offer to employees, or even to check if salaries are similar. Is this also an antitrust violation? I think CADE's investigation is talking a little bit about this. So can you, help us out here?
Sure. So this investigation, and of course I'm based on the public, what is public from the first accusatory piece by the general superintendent. So it seems that this case is mostly focused on exchange of information, right? So that's the big part of the investigation. And it seems that allegedly occurred in two or a few occasions the wage fixing agreements, but still, I mean, this solely focused or mostly focused on exchange of information. And Kaji, the general superintendent gives a few messages on the technical note that I think are important and covers these questions in a way. First of all, the first information is that not all exchange information is illegal. So that probably goes without saying, but it's an important message to put out. Second of all, there are ways that you can use, or there are certain manners to exchange information that will make it legal, right? Which was something we were talking about benchmarking, and I'm going to talk about at the end of it. And third of all, and this is very important, I mean, the general superintendent also understands that there could be pro-competitive results from exchanging information. So that's an important part, because you could actually reduce information asymmetry, and that could actually have an efficient resulting from that act. So these are important messages that are there in the technical notes. But so what is the type of exchange information that general superintendent is flagging as problematic? They're flagging as problematic the type of sensitive information that could impact in the competitive decision of a company in the employment marketplace. So that's our the main issue here. So, and the general superintendent lays out what we can use as a guidance. I mean, and these are very general orientations, but still, I mean, there's something that we can use to understand what is problematic or not. So, and I think Nick went through all these items. So first of all, is information about compensations, right? Not only salary. So we're talking about benefits, bonuses. I mean, and this could be actually reaches a very gray area, as Suzana mentioned. I mean, when we're talking about what specific benefits we're talking about. I mean, we're talking about deciding which cake we're going to buy for a certain person that is having a birthday party. So, I mean, this could be a blurry, right? Second of all, the information should be directly exchanged among companies, so that's problematic. Third, relatively recent, as Nick mentioned, or prospective, right? Prospective information is probably the most problematic, and the recent information is also problematic, but it's less than prospective. Sufficiently individualized or non-aggregated. And of course, the information should not be public. So that's the type of information that is problematic. And once again, it's a very broad definition, and we're going to figure out how Kaji is going to apply that to the specific case. There are two important things that the general superintendent also mentions that will at least give a sense of how problematic is this exchange of information, how serious it is. The first one is frequency. So the more frequent is the information, the more problematic it is, because of course you can have a better idea of the plans of a given company. And the second of all is how specific the information is. I mean, it's very specific, of course, it's more problematic. But I think that there's one thing here that I think it's the most important part of this technical note, and we really need to pay attention to. There's, I think there is a change on the way that, or at least the general superintendent is signalizing that there will be a change in the way that Kaji will review the exchange of sensitive information, right? And there's a particular part of the technical notes where they're saying that there's specific types of exchange information that could be reviewed under the per se rule, right? And this is a very big part of it, because I don't remember seeing that as explicit as it is in other cases. And basically what they're saying here is that they are applying the same standard of review for the exchange of information, for this specific type of exchange of information, similar to what they're doing to a price fixing or other types of cartels. So that's very important, especially because I think that's probably will be the case in this investigation. Why I'm saying that, the type of exchange of information that the general superintendent is saying that should be or could be reviewed under the per se rule or the infringement by object is the exchange of information that is directly made among competitors, right? This type, which is not all type of exchange of information, but when the exchange of information, once again, non-aggregated, recent or prospective, I mean, when this type of exchange of information occurs among competitors, this could be reviewed under the per se rule. And I think that's huge for this case, right? Because we're talking about a case involving, investigation involving around 37 companies that allegedly occur around for 10 years and allegedly involving more than 100 employees. So I think it would be challenging for the general superintendents to actually demonstrate the facts on this particular investigation, how this exchange of information actually impacted a negative effect negatively in the market, so they have competitive negative effects. But what I think the general superintendent is saying here is that, well, for this type of information exchange among competitors, I mean, I don't need to do that. I just need to prove that it happened. I'm actually changing the burden for you, the defendant, to come forward and actually prove that there are efficiencies resulting for this exchange of information. And those efficiencies could not have been obtained by any other less harmful way, which is a very high bar, right? It's the same bar that we're applying for hardcore cartels, right? And I think that's something that I'm not sure if everyone is paying attention to that. And I think that we need to see very closely how the general superintendents will apply this to this particular case, and how the tribunal will analyze this, and whether the tribunal will have the same view of the general superintendency. So that's I think one major point that I want to say. The final point that I want to make is that the general superintendent also says that benchmarking is not prohibited, right? I think it's a huge thing in Brazil, this surveys, and I think that's the subject of most of the questions that we receive and affirmed. So, but companies still should be very, very careful in doing that, and they are giving some guidelines on how to do that. So first of all, you should use a neutral third party to do that, to manage the exchange of information, right? Second of all, the exchange of information should involve information that is relatively old. And relatively old can change jurisdiction by jurisdictions, and relatively old can change market by market. So it's broad, once again. The information should be aggregated and from a number of sources that is sufficient, so you cannot link one information from one specific company, right? So if you follow these steps, that once again, it's case by case, that you need to make sure that you're doing that correctly. This first accusatory piece says that you're safe, that you're doing a benchmark in a way that is legal and can have pro-competitive results. So I think that's pretty much we can comprehend for the first case. It'll be very interesting to understand how this is going to play out.
You know, Luis, perhaps just one quick comment there. I mean, I think one of the risks is that the information exchange, whether or not it's treated per se or its rule of reason, it becomes the smoke that draws the attention of the enforcer, that draws the attention, at least in the United States, of private plaintiffs, class action plaintiffs. And then they dig and they dig and they dig, and maybe they find fire, maybe that as an in-house counsel, you didn't even know existed. So there's a reason to be particularly cautious about information exchange, regardless of how it's treated. And I would caution people in Brazil, even with it, with this statement that it might be treated per se. At the end of the day, it's going to be evidence of some other object defense. So it carries its own sort of aggregate risk.
Yeah, thank you, Nick and Luis. Well, what is really a concern is that sometimes the exchange, it might have exchange of information in trade association, for instance, and if it's treated per se, sometimes the person didn't didn't access, but just to be sent to that person that wasn't aware of this kind of information that could be involved as well. So, well, I hope we have I hope we have more time to discuss that, because there are so many peculiarities that would be important to address at some point. So we're getting to the end, and so the big question is what to do now. So I'd like the three of you to spend 2 minutes just to give us the company some advice on how to proceed, which things we should, after this panel, start doing immediately without any any difficulty, and what we should just tell the HR people, please don't stop doing immediately what you are doing. If you can start, Christian, please.
Sure. So 3 advice. First, don't panic. There are many perfectly legitimate types of exchange of information of HR professionals, and a lot of this exchange is to the clear benefit of employees. And we need to learn from each other. We need to continue to do benchmarking, otherwise we will not improve our company. So don't get it wrong. It's not about prohibiting everything, okay? But second, we need to explain more to our HR colleagues. For decades, at least in Europe, they have thought that antitrust is more something for sales or maybe for purchasing, but probably only for sales colleagues. No. In these days, in the war for talents is intensifying competition among professionals, and therefore we need to explain better where the competitively problematic information starts and where we do need these safeguards. And that's the third advice. Take these safeguards seriously. As Nick explained, as Louis explained, use a neutral third party, avoid exchanging directly information that is highly competitively relevant, such as salary related information, and limit the exchange to ways and mechanisms that avoid collusion, and make it official, and don't attend any unofficial information exchanges, and then you will have a good chance that you can continue with a lot of the useful information exchange in the future.
Thank you. Nick, can you complete, please? Or
Yeah, I agree with what Christian said. It's a new world. And so I think the first thing people need to do is to proactively train and build awareness this way. The one thing I would add is that it is not only the HR teams that are the target audience here, but also business people who may potentially have these types of problematic exchanges or problematic discussions. For example, the people who are attending the trade association events, the general managers of facilities, of factories, who are talking to their counterparts at the factory across town. So be inclusive in your training. From the US perspective, there's been some guidance recently that at least allegedly will provide additional credit for effective compliance programs. So build in this HR component into your compliance policy documents and your training so that you can demonstrate, if you do get into issues, that this is part of your effective compliance program. And then last, just a couple of comments about once you have a sense that there's something wrong. Okay, if you suspect a problem but have no real evidence, take outside counsel advice, investigate internally appropriately under privilege. Okay, don't start calling from the rooftops, but quietly keep it close to the smallest number of people feasible, and then take more advice once you've investigated about what you should do with the fruits of the advice. If you actually see evidence, an email, or hear of a conversation that might run afoul, right? Leniency is in play, at least in the US, so you have to move quickly. You should involve outside counsel in your internal underprivileged investigations, and you need to get the attention of senior management fast. Remember, what we're really trying to do here is to protect our in-house legal teams and protect senior management. So they have to be brought in to the decision-making process as quickly as you can, as quickly after you have the fruits of your investigation. Just a couple of obvious points maybe to close. Try to conduct your investigation in an open-ended way without making people scared. Keep local legal requirements in mind, such as in the US, the necessity of issuing an upjohn warning, and don't go outside the company. For example, if you hear of a potential agreement, don't pick up the phone and have your CEO call the CEO of this alleged conspiracy partner and say, hey, something's going on, right? Leniency may be in play, and you want to have a clear idea of what your strategy is before you start speaking about this outside the company. Back to you, Suzana.
Just before we move to Luis, let me very quickly say, I posted here on the chat to everyone the contact details of our panelists. They were kind enough to allow us to share the details. So if you have follow-up questions, please, they are available to answer those. Please, Luis, let's hear from you.
Sure. I mean, we're already out of time, and I don't want to repeat what Nick and Christian said, because that's basically what companies should do. But the one thing that we've been questioning a lot is whether we should wait for this investigation to end before doing something. So don't do that, really. I mean, as Nick said, this is a new world and people need to be trained. I wouldn't be surprised. There's a number of human resource professionals that never see a antitrust compliance, a proper antitrust compliance training. And this training should be specific. As Suzana very well pointed out, I mean, we have a number of tools now that facilitate exchange of information. We have all these apps, groups, you have these websites that you can do your video conference, these applications. So we need to be very careful with that. And there was always a question. I mean, we've been speaking with clients since at least 2016 from the issuance of the FTC and DOJ guide for human resources practice. But we've been talking about this, but there was always a question on whether CAGIO will actually pursue this type of practice and how CAGIO became aware of this, what are the terms risks? I mean, I think all these questions were answered with the leniency agreement. We have a company that entered into a leniency agreement in 2019, and that's how the case was initiated. And I think that as Nick properly mentioned, I mean, if you actually have evidence and you are advised by external counsel that it could grant to a leniency agreement application, I mean, that should be an option that you could not dismiss. I mean, at the end of the day, Brazil is one of the very few countries where you have few administrative and criminal immunity associated with the leniency agreement, which can be it could be a solution of problems that arise from these questions. But at the end of the day, I think that training is the most important part. I mean, we need to do that as soon as possible. And thanks again for inviting me. It's a pleasure to be here.
So thank you, Luis. So I unfortunately, I have to make a very quick closing here. I wish I could try to summarize the very rich and insightful discussions we had. It seems very clear to everyone that HR-related information is an antitrust issue, so we should be careful. And Brazil, it seems to be following the steps of the US and Europe. So we kind of know what can be done and not to be done, although we don't have a clear jurisprudence here. So I would like to thank so much Christian, Nick, and Luis for your time and your generosity here with us. It's been very useful, and also to let your contact information here for the people that are participating, contact you in case we have more questions. Thank you. Ademir would like to say some final words. No? So thank you all very much.
Thank you all.
Thank you, Suzana. Thank you, Ademir.
Thank you.